Hi, welcome back. I'm Greg Pace. I'm an attorney with Malek and Malek. This is my boss, Kip Malek, one of the titular Maleks. And we got another video for you today. We had a potential client call in a few weeks ago. We were not able to help them, but it was an unusual fact pattern, and I just wanted to ask Kip what he thought about this type of fact pattern. So normally people get injured, a slip and fall, they get hit by something, a physical act happens, results in an injury. In this situation, it was a stress-induced attack. They said being harassed by their boss, and it caused them to faint, and then the act of fainting, that's what caused the physical injury. They hit their head on something after fainting. And I just thought that was an unusual fact pattern, a mechanism of injury. So Kip, what do you think? Do you think that being harassed at work and then that inducing fainting or something like fainting would be enough to allow a claim?
Based upon the fact pattern that we got from this individual, and it's not to say that this isn't real and this didn't happen to him, but I'm not sure that would be allowed workers' comp claim. But the question is, can you pursue workers' comp claims from like stress triggering the physical injury? And the simple answer is yeah, you can. But there's, with everything workers' comp related, there's caveats.
Okay, so what do you think the biggest issue is? Like, which parts of this fact pattern do you think are the easy parts to get accepted? Which parts do you think are the difficult parts?
I think in this situation, the individual is claiming they're getting yelled at, and they're claiming that being yelled at caused them to faint. And we're all have gone through life and had life experiences, both pleasant and unpleasant. And I've been yelled at by many different people, and employers and managers and coworkers and et cetera. And I'm assuming you have as well, unless you're perfect.
Never here.
But the point is, I find it a little bit questionable that caused the person to faint, because I've never witnessed somebody faint from being yelled at.
All right, so just a quick clarification for people that don't know. Let's remove the being yelled at. The person's just at work and they faint, fall on the ground, hit their head on the carpeted ground, they hurt their neck. Is that an injury? A work injury?
So this is a great example, Greg. Is that a work injury? No, it's not a work injury, regrettably.
Right, okay, because there it's what we call an idiopathic injury, which is, I don't even know what that definition is.
Idiopathic does not mean you're an idiot.
You're right, it doesn't mean that.
It's just like something inherent within you. It has nothing to do with your work. It's just like you have high blood pressure and you pass out, or you have like epilepsy and you pass out.
Right, exactly.
Those sorts of things.
So in this situation, you would have just happened to be at work when you fainted and you hit your head on the ground. So you got injured at work, but you could have just as easily been somewhere else. What's different here is what caused the fainting, allegedly, was something work-related, the increased stress. So this person said they were getting yelled at by their boss to the point of it being harassment. I think that would be difficult to prove. That might be a literal he said, she said. But what do you think if it was just like, we're busier than usual. I work at a hospital and we usually get 10 patients a day and we got 200 patients and I just thought it was stressful and I fainted. Is that a work stress-induced injury?
So the causing, I honestly think that might be increased stress, but you don't have to prove it to me. You have to prove it to a hearing officer and or court if it's denied. So the actual case law that gives rise to this cause of action it comes from a Supreme Court case from 1986, by the way. So you kind of have to, these cases, you have to look at what was going on back then. 1986, it was more liberal. I don't think I'm not sure this decision would be held up today.
Yeah, and we can get into that. I got thoughts on the being upheld.
Yeah. But anyways, without going into the details of this, you want me to go to the details of the case or just the case rules?
Just give what the rules are so people know.
Okay, so it's a two-part test, and the first part is the injured worker must show that the injury resulted from greater emotional strain than that which all workers are occasionally subjected. So in your example, you're working in a hospital, and maybe you're working in a hospital during COVID times, and you're having to deal with all these people coming in, and people are dying left and right. I would imagine that's a greater emotional strain than me, for example, right? Or you working in your or other folks. And then, so that's number one. And then number two, the stress to which him or her was subjected in his employment, him or her employment, was the medical cause of their injury. So it's going to be with a lot of these examples, it's going to be it caused, you to have a heart attack or some kind of thing like that. I'm not really sure what stress would other physical type of situation that would cause.
Yeah. So I think factor two there is what's going to be the issue is the proof, the burden of showing that I have nothing in my past that would contribute to this. I just feel like if I have high blood pressure, any indications of prior fainting, dizziness, headaches, things, maybe not headaches, but that's going to be held against me. And if the other side can find any documentation, I think that might be enough just to stop factor two. Is that what your worry would be in the proving stage?
To be honest with you, I think they're both kind of crazy.
Okay.
And I think if number one is so bizarrely stressful, like you're piloting in a jet and well, I don't even know if that'd be a workers' comp thing, but you're piloting a jet and you're like in that movie Turbulence and you have to go upside down and stuff. That's so extraordinarily bizarre.
Sully might have one after he landed on the the Hudson. Okay.
But it's like the narrative nature of number one, whereas like me being stressed, it's like, dude, we're all stressed all the time to varying degrees.
Right. So I imagine this would be a situation where the claimant would have to prove or indicate and remove the idiopathic explanation, right? They would have to have a doctor say this isn't caused by something else, and the doctor conclude that it was from the high stress environment.
I mean, not to go pushing back, but I think you have the eggshell thing as well. I think just because you're prone to heart attacks does not remove this from applying to the people that are prone to heart attacks. Nevertheless, I agree with what you're saying. If you have high blood pressure or you have the history of coronary issues, I think you're going to have a much harder time with this cause of action or this.
Okay. So in this situation, do you think what you actually get hurt by is going to matter? Because in our normal, if you have a stroke and you hit your head on the ground, that's not a claim. But if you're up on machinery and you're high up and you have the stroke and you hit your head on the machine as you fall off, we generally say that would be a potential claim, right? So do you think that'll matter in this high stress environment? Is hitting the ground out, hitting a machine in, or do you think that probably doesn't matter?
I mean, I think that you're going to idiopathic.
We're getting back to so you think at that point that's not relevant?
Yeah.
Okay.
Not, yeah.
And the point that I'm trying to make here is this is a very niche sliver of the law, and there's not really a lot of examples of this for us to look back as precedent. And I think the employer's going to be throwing everything at it. So I think they're going to be making the idiopathic arguments even if they don't apply. And that's what I would just worry a hearing officer kind of getting overwhelmed with the defense.
Yeah, and to be honest with you, I've never encountered a claim like this.
Right. Yeah, and that's the difficulty here. And what Kip said before, this is from 1986. Ohio is a different place in 2025 than it was in 1986, 96, 2006.
Absolutely.
So my expectation, I do a lot of hearings for the firm as you do, is we would have this case law in our back pocket. We would make these arguments. Hearing officer would consider it. I'm not sure they're going to actually rely on it. I think hearing officers are going to just kind of look at the big picture. Does this sound like a valid work injury? Does that sound...
So here's the thing. Remember we talked about soft factors in the presence of hearings, and I think this is where the soft factors, and when I say soft factors, I think these are factors they're like outside of the workers' comp scheme, but they're relevant. And I think, so I'll go over the Ryan v. Connor facts, and we could argue whether or not that would be allowed today, but I'll go over more to the point. There's a recent IC full commission order from, I think, March 1st of 2021. And so you have to look at it. So this is a sheriff. So this is a first responder. First responders get a little bit more deference than, the Amazon box schlepping person. And that's not to say the box schlepping person is less valuable than the sheriff, but in our society, they're given a lot of deference.
I agree.
And this guy was involved in an active shooter situation, and they ended up having a myocardial infarction, like a heart attack. So I think the circumstances around that heart attack, it's the narrative power of that fact pattern that will allow that would be allowed, more so because he's a sheriff and he's dealing with an active shooter, more so than this case law.
And I think that's what I was trying to get at before, is I think the hearing officer at that point is going to hear what happened, and they're not going to think this directly, but in the back of their mind, this just seems like it should be allowed. And when we bring up this case law, now they have something to attach their instinct to. And my worry is, with the person that was just getting yelled at by their boss, the hearing officer is going to think, I don't think this should be allowed. And then they might read the case law we present, but they're probably going to be looking for a reason to not rely on it. And I think that it being from 1986 is going to be part of why they decide not to rely on it.
And also, like, does anybody, realistically, I mean, have you guys ever encountered anybody fainting after getting yelled at? I'll assume that it happened to this lady, but I have never seen that.
So I think ultimately what I would think here is, if this is the sort of argument that you're going to be relying on, I think the facts are going to have to be more extreme and seem like something that an everyday person would just automatically say, like, wow, that sounds horrible. And I'm not sure getting yelled at rises to that level. I think legally it does, but I just don't know in the real world that it's going to be seen as that.
Yeah, and there's a lot of these things, there has to be some narrative drive behind it, and I mean narrative, it's compelling. Like, that is not compelling. And it also sounds like a he said, she said, like, I was getting yelled at, and it's like, were you just trying to get back at this person? And that's the problem. The reality is, with these claims, there's a lot of, regrettably, there's retaliatory workers' comp filings, i.e. you're mad and then you file a workers' comp claim. Now, I'll just give one example where, now this person I don't think suffered a heart attack, but they did get PTSD. By the way, this important point, this has to cause a physical injury. This is not causing PTSD. And I'll give an example that I encountered. A lady was working for CODA, so she was a CODA bus driver, and her CODA bus was being shot at. Right. So, and there's no doubt that it was being shot at. Like, the police came, there was bullets in the CODA bus. And she was there, and she heard the bullets, and she saw them coming in. And so, reasonably, she suffered PTSD. Now, I would argue that that's a greater emotional strain than, me or you or most people would encounter. But the problem is, it didn't cause a physical injury. Like, she didn't have a heart attack or something like this. She just had PTSD. And so in that instance, PTSD, depression, etc., these are psychological issues. And we know that in workers' comp, physical injuries have to cause psych things. So that would not be allowed. But if she had a heart attack, I would think narratively that one may be allowed.
Yeah, and that's another issue here is, here the law for this specific stress-induced would be in your favor, but it wouldn't even rise to the level of seeing that part of the law because there's no physical injury.
Right.
So you're just going to lose the claim from go before you even get to this point of arguing. And this is just an odd conservative quirk to workers' comp in Ohio. Will that change over the next 30, 40 years? I'd like to think it will, but right now we're just nowhere close to that point. And that's another concern that I have is, Kip laid out the law here, and even if a hearing officer, as I fear would happen, would say, hey, I don't think this should be allowed, somebody could file this into court, and I think a lower level court would see this case law and say, hey, this is silly, but technically it fits the law, I'm going to approve it. It might go to the next level, the appeals level, it might get upheld there. And then my worry, and I'm sure this is what you're thinking, if this gets appealed to the Supreme Court, I don't think the Supreme Court is going to uphold
this is done, dude.
And then at that point, there's no more Ryan v. Connor, because the Supreme Court's going to overrule this. There's going to be a new word for it, and no longer is there stress-induced physical injuries.
Yeah, I mean, I 100% agree with you.
Yeah, and that's my worry. So if you're at home and you're saying, hey, sounds like the law's on my side, I've got deep pockets, I'm taking this to the Supreme Court, I think you're just in for disappointment when it gets to the Supreme Court, because the Supreme Court is going to disagree with you.
Yeah, and here's the thing. I don't really have I neither like nor dislike the Ohio Supreme Court. I'm kind of neutral. I don't care. But the Ohio Supreme Court definitely has a position, and it's very business centric. Right. And if you're a small business, medium business, big business, that might be great for you, and maybe for some people that's great. For some other people, it might not be great because these decisions are not necessarily injured worker friendly, and they're negatively impacting the injured worker. So that's just the reality of the Supreme Court in Ohio right now. Will that change? Not now, not anytime soon. So and so we're gonna get decisions like if this were to go to Supreme Court, it would definitely like this fact and so we didn't go over the facts of the underlying Ryan v. Connor case.
And there's a reason we didn't, is because there was just no way it would be upheld now. If the exact same fact pattern happened, there's just no way.
Never at all. And so in this case, this guy, he was told that he had to retire, and he was working somewhere, and presumably liked working there. He was told he had to retire, and so obviously you don't want to retire, and you're told to retire. He went home. He was stressed out. He was mowing his lawn, and then he had a heart attack. And then that's what gave rise to this physical injury caused solely by mental or emotional stress. Do you think that'd be allowed today?
No, it's not even just that he was at home at this point, that he was mowing the lawn, something completely separate, but just being told you got to get a new job is just so far from what would be seen as an increased stress. This was clearly somebody with already a stress issue, and this was just the final straw. And even with eggshell skull and all that, there's no way any court in Ohio is going to say, oh, that definitely is a work-induced injury.
Yeah, and it's because here's the thing: Ohio has become. I mean, there's this from Warhammer. There's this idea called grimdark, and in Ohio's law has become grimdark. It's just tough.
Yeah.
The reality, and so this would not be allowed because I frankly I think the fact that it happened at home is kind of problematic as well.
Oh, I think it is problematic,
yeah. but the retiring thing, I think
every level of it is problematic.
Yeah, and because retiring, it's like, oh, you got to retire. It's like, dude, jobs are being eviscerated every single day. Like, who is not stressing out about that?
Yeah.
Everyone is.
Yeah.
So that doesn't even meet number one. It's a greater emotional strain because everybody is having that.
And then again, I'm not a Supreme Court scholar by any means, but the weak facts of this case is just going to give the Supreme Court even more reason to overturn it as soon as they have the opportunity.
Yeah, 100%. So I don't know. It's an interesting thing, and it just kind of when clients call, it kind of piques our interest. Like, would that be allowed? And it's like, so.
Yeah, and we don't always agree on it, so we just thought that might be something interesting for people to consider. So hopefully you're never in a situation where you're having a stress-induced physical injury. But if you are, this is not going to be a cakewalk to get this approved. So you're definitely going to need to talk to an attorney, whether us or a different law firm.
Yeah, always just talk to multiple attorneys. By the way, find the one you like, because it's going to be really hard to get another attorney to get involved in your case. It's not impossible, but to be honest with you, like even our firm, it's like we're very, very, very reluctant to get involved when somebody else has been representing somebody, because usually there's something weird's going on. And there's problems with that situation. So find the attorney that you like, because you're going to want to stick with that attorney. But yeah, I appreciate you guys listening, and we'll continue making these videos. Like and subscribe, and
if you have any other questions or thoughts on the fact pattern, put that in the comments, and if you have an interesting fact pattern that we want to respond to, we definitely will.
Yeah, thanks.
Bye.